We have now two topics dealing a little bit with cybersecurity and the application of digitized means in arbitration, in today's arbitration already. At first we have Erik Schäfer. He is counsel with Cohausz Floack, and whenever you have something in Germany dealing with technology and arbitration, usually Erik speaks. He will talk about virtual hearings and remote evidence technology in arbitration, and we have selected him because he had been chair or vice chair, I'm not 100% sure, co-chair of the ICC working group on that topic. And we are very much looking forward to your presentation, Erik. The floor is yours.
Thank you very much for having me today. Before I start, I think I will make a not self-interested recommendation. And this is a book about artificial intelligence by a guy called Stephen Finlay. He's sort of bedrock of artificial intelligence, and he has written a nice book which you can read in 8 hours, so perhaps in one day over a weekend. It is called Artificial Intelligence and Machine Learning for Business. Now, a no-nonsense guide to data-driven technologies. I have read it, and I really think it helps a bit to understand a bit better what he was talking about, because we talk about artificial intelligence very often in the sense of a black box. We do not know what is inside, and inside is mathematics, and I think we should be familiar with the ways these systems work and what is required. Because, for example, still today, I believe, you cannot take any data anywhere in any format and feed it into the machine and hope that you get a good result. You have somehow to normalize the data you feed into the system. So I'm going to talk about something which was this morning called systems. I'm not going to talk about artificial intelligence. And I'm talking about something which is sad, because it also foreshadows something bad for artificial intelligence in our field. We do not really well use what we have, technology-wise. We make no conscious, structured, and efficient use of technologies. And I will address this with an example, which is about conferencing collaboration technologies. And to start with, I will have some preliminary considerations, some thoughts, which are theses, and I will then provide you with some example scenarios where you can see how these technologies can operate and how they can be used today in your arbitration, the one you have tomorrow or the day after. First, and this is something we should not forget, personal presence in one room, direct recognition by the arbitrators or judges, has been always a cornerstone of civil procedure, because it best suits, and also for the parties, because it best suits how we are, what we are, how we interact every day. And we can also use all our communication channels. And communication channels are not only the channels that relate to our self-narrative in our head, our consciousness. It's also, I have read in a book, I cannot verify this, that above 80% of our interaction with other human beings is non-verbal and never reaches our stream of consciousness. But it still strongly influences what we do. And sometimes there are decisions taken in that part which is not in the stream of consciousness before the consciousness decides that this is a decision that has been taken. Of course, this is normally in events, you know, when something is thrown at you and you jump away or something like this. Is the reaction that you have to jump away is not taking your stream of consciousness. It happens somewhere else before. But still, I think it's very important because we feel more comfortable. We feel more at home in this personal environment. But in transnational, especially in transnational, perhaps also in national disputes, if the people are far away, the personal presence in one place has inconveniences. If you just look at from the angle of efficiency, you need more time because you have to travel, and you also are a bigger burden on the environment. The expenses increase considerably, and sometimes the expenses that are generated may not be in a good proportion to what is at stake. We have talked this morning or later today or earlier today about small cases. These were about 500,000 euros, but still, if you have a 10,000 euro dispute, it may not make sense to travel from one end of Germany to Madrid or something like this. It's just too expensive. Since at least 3, normally many more persons attend arbitration hearings or preparatory conferences, the additional travel time makes it much more difficult to find acceptable dates. Of course, if you sit in different time zones, if everybody is in a different time zone, you have another problem, which is not mentioned here, but which you can find inconvenient, because if you have somebody in Beijing and another person in Mexico, it might be that somebody in between will have to sit in a room at 3 o'clock in the morning for 2 hours, and this is not the best time of the day, at least not for me, to do serious work. A solution to these issues is using internet-based voice and or video conferencing to save time and financial resources. Technically, this roughly requires high-speed network access at all endpoints, a projector with a screen and or a desktop or laptop computer equipped with a camera, a microphone, software clients, Skype, Zoom, whatever, you name it, and accounts with a service provider that allow all these participants to access to a virtual meeting room. You can also have a dedicated video conferencing unit, which many bigger law firms have, that have all these above features and normally provide much better quality insofar as the communication quality is concerned. This also requires IT staff that can set up and operate the system at all ends. Very often, even if you have the first version with your desktop, laptop computer, you will need an IT guy who helps you to install the system and also instructs you a bit how to handle it. For hearings, sound recording equipment is recommended, even if you can, I will come back to that later, even if these video conferencing systems normally have a facility to store a copy of the whole conference online. Now, let's look not only at the technical issues, but also the legal questions. The legal question is this allowed? And if you look at the arbitration laws, the laws governing the arbitration proceedings, which always should be checked because there might be in some countries a surprise, generally they do not contain mandatory provisions that would specifically restrict the usage of video conferencing technology in arbitration proceedings. However, the general principles, such as equal treatment of the parties and their right to adequately present their respective cases, must of course be observed in order to not to contaminate the proceedings. Setting up the conference, testing the connection beforehand, which is very important, arranging for supervision of distant witnesses if appropriate, organizing document bundles, and so on, which must be in the hearing room and perhaps also where the witness or witnesses are located. If you don't show it on the screen, most people prefer to have printed material shown to the witnesses and not just show it to them on the screen. Require cooperation, factual cooperation among all participants. If one or more participants are unlikely to cooperate, this can lead to disrupting events that may, in the worst case, frustrate the purpose of the meeting and contaminate the arbitral proceedings with procedural issues that may be used as a point of departure for attacking the validity of the proceedings. However, and this must be said because we always talk about the problems in procedure, but most cases do not have these problems. In the vast majority of all cases I personally know, all participants will collaborate as required. One recommendation, if you embark on using technology this way, you really must seek a consensual implementation that means you have to discuss it with the parties, you have to tell them what you are about to set up, you have to make sure that they accept it, and that they also have the means, which will later be required, that everything works seamlessly. This does not mean that this must happen in each and every case, but I think in only exceptional cases one can depart from the consensual principle and order that such a meeting take place using video conferencing technology. Another point which must always be kept in mind is system security and data confidentiality. And this applies to any use of communication systems and IT systems within an arbitration. You need to consider it always, and you have on one hand the threat of possible attacks. And that threat analysis is the basis for your decision whether and which security measures you must take. On the other hand, it depends on what is at stake and the money that is required to penetrate your system. If you have a relatively secure system, the other side will have to make certain efforts which will cost them money. And if you know that somebody would have to dedicate a budget to penetrating your system in order to get information out of your case, it might well be that you say nobody is going to pay to get this information. So if you think it's not important, you have no security concerns, you have not a real confidentiality issue, it's just a sales contract for some trucks that go someplace, you may say it doesn't really matter, and then security is not such a big concern. But in other cases, for example, high-stake cases with the state enterprise involved on one side, which are perhaps even politically a bit controversial, may require very high security measures, and it might even be that you say this technology, video conferencing technology, is something that is too easily intercepted, and therefore we forego this exercise. So the threat analysis must not always be very complex, but in some cases you have to give it more thought. And you will perhaps need advice from technical experts how to best protect the system against penetration. I now come to the sample scenarios, but before I come to this sample scenarios, I would like to point you to a website which I have discovered recently. It's a website where you can see the different products that are on the market. It might not be complete, but it's pretty complete. I had to look at it. So if you consider using video technology and you have not yet a program of which you know it works, with which you are familiar, and which also the others are familiar, like Skype. Many people know how to use Skype, so it's not very difficult to set up. Skype for Business. But there are other programs out there which are more performant, which have more features, which are more convenient to use. And if you want to explore this, go to this site. There are links to all these different service providers, and you can have a look at this. And when you have a look at this, also have a look at their data protection rules and stuff like that, because if you have the whole thing stored on a server in the US, you know there's a Cybersecurity Act. The American government can look into this. If you would choose a Chinese provider, the same thing would probably be true for the Chinese government. I don't know how the act is called. So now we come to the simplest setting, scenario 1, which is pretty often used in arbitration. This is simply a video or voice conference that is set up. The voice conference, if you have participants who have never met, is always a bit cumbersome, I find, because it's a bit difficult to identify the different speakers. If you have a simple, and this is something you can really do on a low level because the quality is not so important, you do not really need to record every word. If you have a preparatory meeting with your co-arbitrators, or even if you have the first case management conference with the parties, and you have a picture, and every time somebody speaks, this picture gets bigger and the others goes to the background, it's far more easy to have a more natural communication situation, and you will feel more comfortable because you have this visual effect. And this is nice, it's not a must, it's mostly done by telephone conference, but if you can set up such a conference, you will probably see that it has certain advantages, and the biggest advantage is you get familiar with this kind of setting and system. So it's not a very dangerous situation if you would do it otherwise by phone call. This doesn't add any more risk than a phone call, and you get more familiar. You see what the system can do, how quality is, how the others behave, and you get a feeling whether everybody is at ease with this kind of system. So as you will see, I always have a vertical dash to show that there are participants which are somehow apart. Here, every arbitrator and the two parties are all in different locations. You will see that I have a little camera and a mic. This is not that you have to have these separate units. You can have it in your laptop, but I just wanted to show what you need. You need the computer, you need the high-speed access with connection to the cloud, you need the service provider, and on each endpoint you need a microphone and a camera, and I forgot the loudspeaker. Yeah, this is, of course, also required. The next setting is the typical setting for hearings where video conferencing is, in my experience, used today. I have used it for the first time some 15 years ago, or 16, yeah. This is the remote witness. Sometimes there is a witness who is not available, or even more witnesses who are not available on the day of the hearing, and especially if this is not one of the crucial witnesses which you would like to have in the room for some reason, you can arrange this via video conference. You have normally in the hearing room your laptops or computers with your own screen and mic, but it's useful to have also a screen and an LCD projector where you can display documents and where you can also have a big picture of the witness. I have not included in these pictures anything that is related to document management because that's not the topic today. I only have it on the side of the witness. Why? The question is, many parties are a bit concerned that if you have a witness in a distant location, he could have a screen texting, a teleprompter in the background, which nobody would see. So the witness during the interrogation could be influenced by somebody sitting somewhere, nobody knows. So the standard procedure, which I have seen in most cases, but it's not really required if everybody trusts that the witness will not be influenced, is that every party will send one representative to this room. The advantage is these two persons can also prepare with the room. They can have the joint bundle of documents and help the witness to find the relevant documents and stuff like this. And then you have the witness sitting there, and the party's counsel and the arbitrators all sit in one location, and they do the witness examination in the usual way. You can decide to have the tribunal ask the witness, but this is an arbitration, not the usual way. Normally it would be counsel who do the normal witness interrogation on the basis of some written witness statements. There's nothing else that needs to be said about this. Something I have not yet seen in arbitration, but what I have seen in my practice, is the virtual site visit. You can have the tribunal and the parties in one room, and you have an expert at the location, at the site, somewhere else. All you need is high-speed access at all places. And you can direct via a dialogue the experts to different parts of the thing that needs to be inspected, and he or she will explain how that works, and you will get a first impression of really what the dispute is about without having to go to the sites of the facts. Of course, this is not always helpful, but it might be helpful, and this will really spare a lot of money and time, because otherwise everybody would have had to go to this site, which might be far away. I have seen this in an IP case where we had the client in one location in Belgium. We had co-counsel in another location in France. We were sitting in Düsseldorf. We had our big professional video conferencing system, and the client showed us a machine. It was about how a machine works, and the question was which features of a patent are being implemented in that machine. So we went to the different parts with the video cam. You have a live cam, you move around and you ask questions and you explain, and you get a pretty good picture of what is going on there. I believe that this is, as long as at the site where the expert is, you have really good broadband connection, normally Wi-Fi, is present, something that should be considered, and in my view, is not being considered often enough. So it's better to have this than to forego this site visit at all. The next scenario, this is the most sophisticated scenario because everybody is in a different place. Works more or less the same way. What is the problem here? This could also be a problem in the case management conference. One problem is you have one communication channel. Everybody listens to everything. The arbitrators need sometimes to retreat and discuss. And you cannot just switch out the video conference and set up a new one and then go back again and forth. This is error prone. So probably you will have to agree on a second communication channel among the arbitrators, which could be a fixed phone line, and you mute your video conference and you have your discussion while the others wait on this second communication channel. But you have to provide for this beforehand. Another issue is, can you sit a whole week, 2 weeks, in your office, seeing 20 witnesses, looking at the screen all the time? I think there we reach our human possibilities. I mean, I would be pretty unhappy to sit in my office without having contact to anybody 8 hours in a room. So I believe this scenario is nice, but probably only for very short hearings. It might be that you have an expedited arbitration procedure. You know that the arbitration rules provide very often that in expedited proceedings you need not have a hearing. I believe that this is better to have this than no hearing at all. It probably gives more satisfaction to the parties. Because law and administration of law is not only getting the right result or solving the dispute, people must always somehow feel that a fair or just decision was rendered. And this depends on what I mentioned in the beginning, the communication that is not just driven by efficiency, it's driven by our human nature. So probably before we don't have that at all, that might be a solution. What you also forego, of course, is this little chat during the coffee break that sometimes, in my experience, triggers interesting processes in an arbitration. You just drink a coffee and counsel walks up and says, this was very strange, and then the other side comes, says, this was very strange, and say, yeah, but do we really need this? Can we not? And then you can find a procedural agreement on a certain issue, or you can generate a dynamic that can lead to more interesting settlement discussions. You do not always need to have 100% settlement or something, or decide any issue. Sometimes these little agreements build slowly up an atmosphere that is more cooperative again, and then you have windows of opportunity for a settlement, which in my opinion is always better than a decision, because the parties to a settlement have retained the decision in their own hands. So I'm not advocating forcing people to settle, but there are opportunities, and I believe that if you're not in the same place, these opportunities will not occur as often as they would if you are in one room or a set of rooms. And with this, I finish. Thank you very much.